When people contact our office and seek to do a modification to their parenting plan, they're often coming because there's some sort of an issue. Either one parent, maybe they're not exercising all their parenting time, so perhaps it makes sense to officially modify and change the parenting schedule and to have that documented in writing. Another reason is there may be a reason to relocate. One of the parents is moving or relocating, and that will have an impact on the visitation schedule. So if one party is moving and it's going to be an hour away, for instance, that may have an impact on the other party's ability to continue to maintain the parenting plan that's already in place. To legally modify your parenting plan, it is best to start a proceeding in court so that you can have a judge finalize any agreement that you reach with respect to a modified custody arrangement. For instance, I've had a number of clients come to me where there was going to be a change in the parenting schedule for a variety of reasons. It could be one person was relocating, or maybe they just couldn't keep up with the schedule. They needed to change it. The days were just different, and they wanted to document it. And they knew this up front, and they knew that they both agreed. So what we did was we signed a settlement agreement. We did start a proceeding in court, but the whole reason was not to do a whole litigation, but to tell the judge, hey, we happen to work everything out. We're going to be your favorite case that you have on the calendar because there's nothing for you to do, Your Honor, except to rubber stamp this agreement that we have. Another way is to actually start a proceeding if your partner doesn't agree on the changes to the parenting plan that you're proposing, is to start a proceeding in court. Typically, we start it in family court. You can also have this heard in Supreme Court as well, which is the lowest court in New York State. Either way, those are the appropriate venues. And you can present to the judge what the situation is, why there needs to be a modification in the parenting plan, and ask the judge to do a modification of the parenting agreements. A substantial change in circumstances could be, for instance, if the other party isn't exercising their parenting time, you're going to want to maintain, I suggest, a notebook or a calendar that shows what the parenting schedule is and whether or not the other parent showed up for those actual visits and exercise their parenting time. If there's a significant amount of time in which they're not exercising their parenting time, or they seem to be coming on different days, and now you want to modify it to a particular day because the parenting schedule is no longer working, that would be a reason to modify in court. Another reason is relocation. Relocation is huge. If there's special circumstances that require relocation, you're going to need to demonstrate to the court why it's a good idea to relocate to this other jurisdiction and therefore seek a modification. Other substantial circumstances could be there's something happened to the child, there is a special situation going on with the child where they need to have certain care. Those may be valid reasons and substantial changes in circumstances that require a change in the parenting agreement. Sometimes a party may feel that it's necessary to do a modification to a parenting agreement simply because the other parent was sick and they needed to change the schedule for a couple of weeks here or there. Unless it's something chronic and persistent that's happening a lot or all the time, a one-time modification or change to a parenting plan is typical and normal and what's expected. While you have a parenting plan that's in place and that is something quote unquote in stone, it is the default, meaning, we all understand that life happens. People get sick, people go on vacations, or they have business trips or other reasons that the parenting plan needs to be modified. Maybe there's a special occasion in the family, like a wedding, that it's important for the child to attend, so the schedule might be modified. So these are typical, normal events that arise from time to time, and it is expected that the co-parents would discuss this with one another, agree to an arrangement so that the child can benefit from the change for whatever the situation that's coming up. But unless it's something chronic and happening on a regular basis, month after month or week after week, a one-time situation is not really reasonable to ask the court to modify an agreement. If you have any questions about modifying your parenting agreement, or maybe you have a unique situation that you're not sure if it would comport with some of the modifications that I've suggested, please give us a call. We're here at Sabra Law Group to help.